And now we are going to have a mock class taught by Dean Milliron. Dean Milliron is the Associate Dean of Academic Affairs. She is going into her 16th year with the school. She started in the legal writing department and became the director of the program. She graduated from Michigan State College of Law and worked first in insurance defense litigation and also for the Michigan Court of Appeals. She has been in law school education for approximately 24 years. Thank you, Dean Milliron.
The first thing I'm going to say, that 24 years just indicates that I was a child prodigy. So welcome, Ave prospective students. I get the honor of giving you a little bit of a taste, kind of wet your whistle for how lawyers think. And I'm hoping that I don't start to see participants log off as I move through my class. So it's going to require participation on your part. So I'm good. I was really happy to hear that you're able to unmute yourself and ask questions of our former panelists. So I am going to give you a little bit of a background. I hope all of you, if you can give me a thumbs up, we're gonna have a million thumbs up, that you got the exercise and that you have read it. I'm gonna be pulling it up and sharing my screen in a few just to kind of go over it, but I'm hoping that all of you have gotten it. Is that the case? All right, so far I'm seeing people chime in that they got it. So the purpose of this exercise, it isn't like case reading that you're going to do, let's say in your doctrinal classes, but it's thinking analytically like a lawyer. So the laws in the United States, we adopted, I'm going to start with the common law. We adopted a good portion of our law and followed England with common law. And common law is developed through fact patterns or things that have gone forward to courts. It actually started way, way back when they were trying to settle, and you'll find out some of this from Professor Gillen when you take Moral Foundations, when they were trying to settle disputes within small towns. And what it would go to is a judge, and the judge would look at those particular set of facts and make a decision, and not only make a decision on those set of facts, generally tell why. And the why is what starts to develop a rule that would possibly be used in the next case. So let's say somebody steals someone's cow, and they rule on stealing a cow is breaking the law, and so you get such and such. Then the next thing that comes along is somebody steals a goat. So now they know that stealing some sort of livestock could be potentially a crime. Is a goat going to be of the same punishment? So that's kind of how law is developed. And then in the United States, what we did is sometimes when you get so many common law cases and the law is developing, the legislature will see that it's an area of interest and they will codify it. But for the purposes of this exercise, we're kind of going to work through what it would be like to have a common law fact pattern, and then how the law develops when you look at the next situation that might be the same, might be different, and how you might have to tweak the rule that you've extracted from the first court to look at the next fact pattern. So I'm going to call on my first, I'm not going to cold call, but let me first share my screen. Give me a moment. All right, so I got to make sure I can pull up the participants there so I can see who's raised their hands. All right, so if I could ask somebody just to explain to me, just up through where it says number 1, because those are the little exercises that we're going to do, what's happened in our fact pattern? What went on in this situation? You might as well get your juices flowing, because in law school, this is what you do. You talk in class. Oh, I can see everybody jump into it. Anybody willing to tell me what happened in the fact pattern? This is the easy stuff. You're just regurgitating what's there on paper. Okay, so I see you're going to be a tough crowd. This is going to be a long class. All right, so basically we have our Mallory was killed when while he was driving home from a baseball game. He was driving.
Oh, we have students raising their hands. You just have to allow them to talk. There you go.
Perfect.
I think Mona.
Have somebody else talk than myself. How about Mona? Would you tell us what happened in the fact pattern? Off from where I was.
Can you hear me?
Yep, sure can.
Okay. So basically, just to summarize it, there was an individual who had gone to the bar he had already showed up. He was intoxicated. He left the bar after watching a baseball game and gotten into a car wreck. John Mallory was killed, and then it was a matter of who was to blame, whether it was the driver or the bar that served. Was in fact the bar that was liable, because he had shown intoxication when he originally showed up, and then they continued to serve him after that another 5 drinks over the course of an hour, and they failed to meet their responsibility. So yeah, that was it.
Mona, well done. So I don't know that it was necessarily a choice between whether the driver was at fault or not. It's just a matter of, I think in this instance, maybe going after the deep pockets, which might be the bar, to see if they're liable for their part in this situation. So when we look at the third paragraph here, we see that this is where we get the information of what the court decided. So based on of this, let me give a little bit of a background. When we're deciding cases, a lot of times the courts develop a rule, and a lot of times that rule will have components that need to be proven in order to be able to recover the next time around. That a lot of times it's called elements, sometimes it's called prongs, they have different, but for the most part, you're going to be learning a lot of elements when you are in your first year of law school. So based on the court's decision here, what things do you think were key that we would, if there's a new fact pattern, would have to prove to be able to hold someone liable for someone being hurt in a car accident and alcohol being involved? Okay, Brad, I'm sorry. I had it pushed away where I couldn't see people's hand. Brad, can you tell me something? Give me one thing that you think the court would have to show. I mean, the person would have to show. Are you there, Brad?
Is this Brad? Yeah, this is Brad.
Okay, perfect.
Okay, I think that they have to show that the bartender realized had that the person was intoxicated, and then didn't exercise good judgment by not serving them anymore. He continued to serve them.
Okay, well, you just go ahead.
And I also think that they should have some reasonable expectation that they're going to put themselves in some sort of danger, or the public. They're at a bar. Most people drive to the bar. I think if you've got somebody in there drunk in your bar, you should have some idea whether they're going to be driving, walking, somebody's picking them up.
Okay.
Especially this guy was extremely intoxicated.
Okay, so Brad, you've made a couple of points, and I'm going to kind of comment on that. You brought out a couple of things that the court said, and that was good. You brought that they served alcohol, okay, to a visibly intoxicated person. Those are two of the requirements that the court talked about. Now, the other things that you talked about, the court doesn't really talk about, having a responsibility, knowing that they drove there. Do you see any of that in the court's decision?
No, I don't think it's in this particular decision, but I think in some of the cases down below it might apply.
Okay.
Because
so
if you're drinking in a bar and you're drinking at a sleepy time in, you might have a different level of, if somebody's going to walk to their room, or if there's somebody's going to have to drive away, it might change the level of your responsibility, whether this case or not. In the other cases, it might be applicable.
So Brad, this is where you need to be careful as a law student. When you're when you're looking at the law and looking at the cases before you, you have to look at actually what is solely presented in front of you, and your worldly experience as to how these things have been handled or what would be the situation might not be relevant. And students struggle with that because they bring what they think should be something that would hold someone liable to class, but you're really going to be looking at it based on what the court said. So what you say might be right in terms of a logical sense, or what we think would be correct, but we've got to look at what the court specifically says needs to be proven to be able to bring a cause of action. Now, if someone else would volunteer, he got served alcohol and visibly intoxicated. What other thing was going on in this fact pattern that made them liable? Brian? Brian, are you there?
Yeah, can you hear me?
You might have to speak up just a little bit, but I can hear you.
Can you hear me now?
A little bit better, yep. So what other thing do you think is going on in this fact pattern other than serving alcohol and visibly intoxicated that made Harry's Bar liable?
So the question to me is that Harry's Bar was liable and not the bartender at Harry's Bar, which makes me think that the employment relationship between the bartender and the bar is important here.
Right, so that's what respondeat superior, some lovely Latin that you'll learn when you go to law school. And one piece of advice when you come to law school, have an app or buy yourself a good Black's Law dictionary, because you're diving into a foreign language when you start law school, and you're gonna need something handy dandy right there so that you can look up terms and understand what's going on as you read. So it looks like in this fact pattern, we had someone who served alcohol to a visibly intoxicated person who by respondeat superior, because they worked for Harry's Bar, made Harry's Bar liable. Everybody tracking with me so far? All right, so I'm gonna figure you are. So I'm gonna read the next fact pattern and we're gonna have you guys weigh in. So Art Melchior was driving home from Joe's Bar when he ran a stoplight and hit Emily Evans' car. Emily was seriously injured. Joe, who was tending bar that evening, remembered Art was high after he consumed a couple of pints of English ale in an hour. Joe served him one more as Art was a good customer. Is Joe's Bar liable to Emily Evans for the injuries caused by Art? How about, is it Gerds?
Can you hear me?
Yeah, sure can.
All right. Well, according to the previous case that we're looking at, it looks like Joe's Bar is
Piece
liable.
by piece. Okay.
So it looks like Joe's Bar is liable. Let me refer.
Okay, so let's go for the first one. What facts, so we're gonna find a home for our facts. What facts show us service?
Because it says, remember that Art was high after he consumed a couple pints of English ale. So it shows that the bartender was cognizant or like conscious of what the bartender was doing.
Okay,
Just like
so
in
let's go.
Huh?
You're right on track, but let's go back to these elements. We have visibly intoxicated. So you're saying that because Art was high after he consumed a couple pints of ale. Does everybody figure that that shows visible intoxication? Is everybody good with that? Anybody have a question on that? Mona, do you have something you want to pipe in up?
Go ahead, Mona. Hello, Mona?
How about,
I'm sorry,
Yeah.
can you hear me now?
there you go, Mona, we got you now.
Hello? Okay,
Mona,
great.
so did you,
I just want to make sure that I understand the interpretation of high. When we're talking about high, are we talking about under the influence of a substance or of alcohol?
that's an excellent question. I think as an attorney, you would have to make sure that the word high means the same thing as did visibly intoxicated earlier in our fact pattern. So I think the court, you'd be going to the court to ask them for more clarification on what high means and how far that goes. So good point. I'm gonna go back to Mona. You still there with me, Mona? I'm gonna keep you on or no, Garrett.
I think it was Gerds.
Garrett,
Yeah.
yeah, sorry.
Still there with you.
Hi, so what facts show me that, okay, so we've got visibly intoxicated, or at least we have a question about it. It seems to be there because we might say that high is the equivalent of it. What shows us service? And I know this seems obvious, but I need you to tell me what facts indicate that element is satisfied.
What element is satisfied about respondeat superior?
No, service. I know, it sounds obvious, but I want you to tell me what facts show that in our number one.
Joe served him one more as Art was a good customer.
Perfect. I know that seems obvious, but you've got to make sure that sometimes you state the obvious so the reader, which is going to be your professor or the person who's listening to you, understands that you're going through each of the elements. Okay, last part. Respondeat superior. Is it satisfied here? you.
Yes, it is, because it's showing that the Harry's bar is responsible under the doctrine of, because it served as someone who's already intoxicated.
Right, respondeat superior means that there's somebody, we're trying to hold Joe's bar liable. So what connects this to Joe's bar? What facts?
I think Matthew had his hand up.
Joe was tending bar. Okay, so it connects Joe to Joe's bar by respondeat superior. It might even be more if Joe's the owner of the bar. All right, so let's move on to the next one. Milt Davis is a traveling salesman. He was staying at the Sleepy Time Inn on a recent trip. He went to the bar at the inn for a gin and tonic before dinner. He had two between 5 and 6, according to Evelyn Saunders, the waitress. He then left to drive down the road for dinner. While changing lanes abruptly to turn into a restaurant parking lot, he collided with the station wagon filled with children on their way home from a birthday party. All the passengers suffered minor injuries. Is Sleepy Time Inn liable to the passengers for the injuries caused by Milt Davis? Can somebody take me through the analysis of the elements, showing me what the facts are satisfied? How about Adam?
Go ahead, Adam.
Can you hear me now?
Yep, sure can.
Okay, good. So the facts of this case, he was staying at a Sleepy Time Inn. He went to the bar. It says for a gin and tonic, but it specifies that he only had two while he was there. The waitress does not remember him being intoxicated. So even though it was service, it would not fall under respondent superior because he was not inebriated, so the duty of care would be fallen off of the Sleepy Time Inn and go back to the driver.
Okay, I think that you have some pretty good analysis here. She did serve him, and she was a waitress of the bar. So we got service and we got respondeat superior. But what we're missing in these facts are something that indicates that she served him while knowing that he was visibly intoxicated. He'd had a couple, but it doesn't indicate that he was showing any signs of intoxication. So I think you did a nice job there. All right, so let's move on to number 3. Oh boy, this is a long one. Mort Adams is the pitcher and captain of the Peppery Pizza softball team. The teams play every Monday and Thursday during the summer. After the games, the teams go to a local beer garden and share pitchers of beer. The beer garden sells burgers and beer from a counter. Excuse me. The patrons carry their purchases of 1 to 24 tables set up in the garden location. One Monday evening, Mort went to the counter and bought the first round 2 pitchers of beer for 11 players. Al bought the next round and Joe bought the final. Mort drank heavily from each round while the rest of the team shared the remainder. After the second round, he showed signs of intoxication. Mort ran a stop sign on the way home and collided with the pickup truck. Cheryl, who was serving beer at the counter that night, remembers the team. They come in twice a week during the summer and occasionally during the off season. Mort was not intoxicated when he bought the first round. Neither Al nor Joe show any signs of intoxication. Is the beer garden liable for Mort? For the Mort injuries that Mort caused, excuse me. Paige.
Can you hear me?
I sure can.
All right, wonderful. My only question would be, did she notice that Mort was intoxicated after the first round? Because if that were not the case and she did not notice that he was intoxicated after the first round, that I don't think there would be a case for respondent superior.
I think that's a good point. Does anybody else have any other concerns with this fact pattern? Let's try Andrew. Do you have anything you want to weigh in there?
Can you hear me?
I can hear you, Andrew.
Yeah, like you said, Mort drank heavily, but he bought the first one, so she had no idea Mort was drinking heavily, especially because his friends, I can't read it right now, but his 2 friends bought the other pitchers, so she didn't know that he was drinking heavily, and she had no way to tell because she was serving beer to other people.
Okay, so I have a question. Is there something different in how the employees function in this fact pattern from the other ones? What facts indicate service? Is it Imani?
you hear me?
I sure can.
Hey, so I actually didn't. I was actually trying to answering the question that you just asked. I was actually going to answer the previous question. And the
Oh, now you're on the
young
hook
man
for
that
this
just,
one.
I know. So wait, so I'm sorry. So basically, you said what was the difference in the employees? So you asked the question one more time. I'm sorry.
So, okay, so we've got some indication that there was some visible intoxication. Was there service in this problem?
I honestly don't think there was an issue with the service, only because the difference in the previous incidents and this incident was that the first one, they came in intoxicated. So they saw the fact they're intoxicated. I think the fact that Mort didn't buy the second and the third round says a lot into why they wouldn't be liable in the situation.
Okay, all right. Does anybody, that's a really good point. And I think that the fact that we're not sure if she saw him when he bought that he was visibly intoxicated, but what's different in this than there is in the last two? How about Deborah?
Can you hear me?
I sure can.
Oh, wait. So I was going to say for this one, it says that the patrons carry their purchases to the tables. So I don't know if I'm interpreting this right, but so I'm guessing that like the people that buy the pictures, they carry it to the tables themselves. Is
So
that
what makes that what about that is different? Why is that different?
So she's not serving it directly to Mort. So maybe like if he had bought the first picture, if she had to go and bring the picture to his table, she would have seen him getting more and more intoxicated, which would have made her, have the judgment like, okay, he's getting intoxicated, I should stop. But in addition to the fact that that Al and his other friend went up and bought the pictures, and that she wasn't serving them directly, so how would she see him getting intoxicated if she wasn't the one going to the table, as opposed to the other cases when they were serving them directly and they could physically see them intoxicated?
Deborah, that's an excellent point. Maybe you all aren't as familiar with beer gardens. I know they had quite a few when I went to University of Michigan, and there isn't necessarily direct service. You go up to a counter, you get your beer, you walk away. And it doesn't even indicate necessarily Cheryl served them as they came up and doesn't know where the pitchers are going. And on top of that, doesn't know who's consuming it because it's a pitcher of beer. All right, good point. So there's some question there as to whether there'd be liability, because while there was visible intoxication, can you connect that visible intoxication to direct service to create liability? All right, so let's move to the next one. We're doing a good job here. Janice Harmon gave a New Year's Eve party. There were about 50 guests at various points during the evening. She provided a quarter keg of beer and jugs of red wine, as well as cheese, pretzels, chips, and dip. Sounds like a fun party, but way too much social interaction for our day and age. One of the guests, Marty Bowles, caused an accident while driving home. His car clipped the back left side of another vehicle. The passenger sitting on that side was injured, and Marty's blood alcohol level was a 0.15, which, according to the sheriff's deputy, indicated he was intoxicated. Is Janice liable for the injuries her guest caused the other motorist? And before I call on someone, if you see the pattern we've been going through, we're going through the elements: service, visibly intoxicated, respondeat superior. So how about Todd?
Go ahead, Todd.
Do you hear me?
I sure can, Todd.
Well, I would say in this instance, because they weren't, like you're saying with the fact pattern, there was a lot of drinking, but there wasn't anything that was visibly intoxicated. So it doesn't really make any sense to go ahead and charge Janice, though I think it's bad manners if you're hosting a party to have people drive where there's going to be alcohol while you're driving, to not take the keys. I don't think she could be held liable for it. Just because, yes, there was, he did get pulled over and pulled a 1.5, but it just doesn't, I don't see anywhere in here where they could hold her accountable for it, because it doesn't say anywhere in here where he was visibly intoxicated.
Todd, that's excellent. I mean, it's a good point. There's nothing in here that indicates that there's visible intoxication. Is there any other problems with the elements? Is there service? How about, let's see, I gotta scroll down here. How about Brad?
Yeah, one thing that's different is that she's not a professional. The other ones are businesses. They're employing people that are doing the work. She's not a professional. That's a big difference. And of course, that it's similar to the case before, that she's serving a general 50 people. She's not individually serving anyone.
Excellent. Two very on point points. Number one, we'd have to make a big decision as a court. Are we going to extend this to people in their personal homes? And if any of you are familiar with this type of law, most of these have been now codified. There's statutes with regard to this, and there's usually a different standard when we apply this to people in their homes. And secondly, it is a lot like the beer garden where people were helping themselves, and it's hard. So it seems to me that in this one, we don't have service, we don't have visible intoxication, and we don't have respondeat superior. That would be a big decision. Are we going to carry it that far? All right. We were working really hard. Let's see. Let's do this last one. Martha and Harold invited 5 couples over for cocktails and dinner. Harold did the cooking. Martha served the bartender. Each guest had at least 2 drinks before dinner. Harold had prepared 5 courses of dinner, and Martha served a different wine with each course. Oh my goodness, they should have taken people's keys. Although everyone was inebriated by that time, Martha poured brandy for all to cap off the evening. One of the guests ran into a police car on the way home and injured the police officer. Are they liable? Let's see if I can call on somebody different this time. I'm beginning to forget who I called on.
Matthew?
Matthew. No, I talked to Matthew this last time. Michael.
Michael, there we go. Go ahead, Michael.
Are you there, Michael?
Can you hear me?
There we go.
I sure can.
Okay. Of the 3 elements, I would say that they would be liable because they were serving alcohol. The guests were visibly intoxicated, and then she decided to serve the last brandy to cap off the evenings, and so I would say they are liable for it.
And there's one sticking point here that's different than the first 3 fact patterns, and what would that be?
Is I guess that it's not a professional organization.
So the court, right, the court would be making a big decision of whether they're going to make that leap into the private home to create liability and create a new precedent in that area. Right. You guys, I got to say, I was a little nervous coming into it. First of all, there's a lot of you here. Secondly, you know, whether you all were going to participate, I really, really, truly appreciate it. This is a fun exercise, and it kind of gets you thinking how lawyers think. One thing, if you come to AVE, you will sure enough have my husband, Professor Miller, as your property teacher, and the thing that he tells students, as I said earlier, is find a home for your facts. One thing that you guys did an excellent job of is taking the facts from the first fact pattern and then seeing what facts we have to make those analogies and distinctions. And that's a big portion of what you're going to be doing in the law. You're taking that rule and you're making an analogy to how something was viewed before based on how the facts were viewed in the previous situation. So I really appreciate you've made my work a little bit easier. It seemed like it was going to be a tough crowd, but it definitely got better as we moved along.